Hey everybody, it's Craig Valine here, and today I'm here with Dan Kimbell, a 30-year veteran IP attorney living in Oregon, previously from Pasadena, California. And hi, Dan. Thanks for being here today.
Hey Craig, hi everyone.
Dan, I got your free gift, the 25 essential tips to protecting your intellectual property. And I thought we'd go through a few of them just to kind of clarify what you mean by them, because they are tips and actual recommendations, but maybe we can get some clarity for some of the viewers here.
Sounds
So,
great.
first, before we get started, talk about your journey, how long you've been in the business, what your training is, etc.
Sure, I've been an IP attorney for over 30 years. I studied chemistry at UCLA, so I got a degree in chemistry. I did some work in labs, decided that I'm not a lab kind of guy. I don't want to be in a lab all the time. So one of my neighbors growing up was a patent attorney, and he said, I came to his office. I was a young guy, like 20 years old. I came to his office, and he said, "This is great being a patent attorney because you get to wear suits and you can make pretty good money, and you can be around science, but you don't have to do it." And I said, "Oh, that's perfect. That sounds like what I want to do." So eventually I went to law school, took a couple of years off, lived in Japan for a year, learned a lot of Japanese, had a great time, came back and went to law school, and the rest is history. I became an IP attorney. And in the meantime, I've done a lot of startups where I've actually been the entrepreneur starting tech companies. I've started 4 tech companies. So besides doing patents, I've actually done tech, and I know how IP is so important. If you're running a tech company, it's really critical. The last one I did was a pharmaceutical company, which we actually got a patent on a pharmaceutical, and then we ended up launching a company that got FDA approval and launched the product, and the product's on sale. So it was a long journey, but it was very difficult, but it was also tons of fun. So I learned a lot in that process. So besides the law, I kind of have a lot about the entrepreneurial side of IP and how to incorporate it.
That's awesome. You certainly are an entrepreneurial IP attorney. So
Yeah, I'm an entrepreneur at heart with an IP attorney, overcoat, I guess.
Well, we have a lot of entrepreneurs, inventors, course creators, authors, experts watching this video. So I want to go through and ask you a few questions that are in
Sure.
that 25 essential tips for protecting your intellectual property, and maybe you can expand a little bit on them.
Okay.
The first one was recommendation is to understand the different types of intellectual property, familiarize yourself with patents, trademarks, copyrights, and trade secrets. Can you kind of go through each one of them and kind of talk about what they do for the person who gets them?
Sure. I think it's always important to understand basic vocabulary. So when you talk to people, you understand the concepts. So intellectual property is a big basket. It includes different types of things. And they're unlike real property, where you have like real estate, like houses and apartments and office buildings. These are assets that have value. They're basically things created in your mind. So first of all, there's patents. Those are inventions like, machines, chemicals, processes that are invented in your mind, and they are reduced to some kind of machinery or process, so they can convert low cost material into high cost material. So that adds a lot of value, right? So our economies and our world is built on intellectual endeavors. So patents is the inventions. And next are trademarks. Trademarks are source identifiers. So if you hear the word Apple, you immediately think of, besides the Apple you're eating, the great tech company that makes iPhones and iPods and iPads and all kinds of new stuff. And then I guess the new thing is going to be these augmented reality glasses. So it's kind of cool. I'm not into it yet, but supposedly it's going to be a huge thing. So source identifier, and American Airlines, you hear that, you think whether you like them or not, you know who they are. So trademarks tell you who you are. And if you have goodwill associated with a trademark, people will say, "Oh, your cars are great. Maybe other things you make are great." So you'll buy them. And so trademarks are good. Copyrights are more like artistic works. So if you're an author or a songwriter or a playwright or a graphic artist, whatever you create, like works of art and architectural works, if you're an architect, if you're a photographer, your photographs can be protected. So those are copyrights. The last big category is trade secrets. So if you have some process, or if you created the KFC secret recipe for fried chicken, then that's a trade secret. Supposedly it's a secret. I don't know if it really is or not, but it is a way, there's some benefit because no one else knows how you make this wonderful fried chicken, or the Coca-Cola recipe is another, secret that's been held a long time where, you can have that flavor, and the value is because you know it, but no one else does. So that's trade secrets. And those are, again, the four major types of IP.
Related to trade secrets, Elon Musk made his cars open source versus trade secrets. What's the difference? How is Tesla still protected with an open source agreement?
Yeah, well, open source are interesting. That's kind of a decision people have to make. Like, what kind of environment do they want? Do they want other people developing, goods and services within their environment? If they think they have a good enough brand and a good enough model, then other people will come in and develop for them and within that environment. So they'll basically, like, if they have computer code, they'll let it go out there so people can copy it, and then maybe new apps will be created so people can use it and be part of your environment. And then that's like the open source. And closed is where, only you have to, license our code and we don't share with anybody. It's kind of a different mindset. They both can work. It's just kind of which one is appropriate for the kind of business you have. It's a difficult decision, really, but both models can work very well. It just depends on what model you have and you want to pursue.
I'm sure there's strict rules as to what they can do and what they can't do. So no one's really duplicating Tesla, but they're maybe using the code to generate a workable device. But anyway,
right.
The people watching this, I don't think, and I'm not meant insulting anybody, I don't think we're talking about Tesla inventions right now, but we could be. Who knows?
I just bought a Tesla last Friday, so actually
congratulations.
A Tesla guy now. So
number 2 said, identify and categorize your intellectual property assets. Recognize the valuable assets you possess and classify them accordingly. What does that mean?
I think, like a lot of things in life, you kind of have to assess where you are. And, sometimes you have to just kind of like say, lay it all out. Like, do you have any patents? Do you have any trademarks? Do you have any trade secrets? Do you have any copyrights? And you may actually have some of those. Maybe you have some things, like, for example, you may be unaware, but maybe you have some trade secrets. So maybe you have processes. If you're a manufacturer, you may have some processes that allow you to make your thingamajig, more efficiently or better than others, and you may not even be aware of it, but you might have trade secrets. The other kinds of protect, like another one is trademarks. You can have common law trademark rights, and you don't actually have to get a federal or state registration. So if you've been using a name associated with your business, like goods or services, you may have trademark rights. Now, they're good, but if you get federal or state registration, it can even be better for you. If you're thinking like you want to protect it better, or if you ever want to sell the business, having registered trademarks give you a higher value because it actually increases the value of the trademark. Patents, if you have a patent, you'll know you have a patent. Right. One good reason to kind of put everything together is oftentimes people will get patents and then they're not really utilizing them. So maybe, especially larger companies or nonprofits, they will keep getting patents over years, and every few years they have to pay maintenance fees. And then they just pay them rather than decide, is it worthwhile? But if you have them and you evaluate them, you can decide, do I keep spending money on this, or do I just pull the plug on it and let it lapse? So just knowing where you are is really a good position. So if you just lay everything out and you can decide, should you continue to put money into it, or maybe it's time to pull the plug.
Yeah, one of my questions when I meet with new clients generally is, tell me about your marketing assets. And your marketing assets could be past customers, could be previous works. Like for me, I have done so many presentations that some of those could be combined and created into a course. I mean, they're all marketing assets because I can use them and monetize them at any point. But
That's right.
so you're talking, so it's similar though. So we might have books we've written, reports we've written, presentations that are on video or something like that we should protect.
Yeah, because a lot of times what you let's say, especially artistic assets or written works, you can just kind of cut them up and reframe them and use them in different ways. My eldest daughter is an artist, and she's constantly reworking things she did years ago and then kind of repackaging it.
Yeah.
And then she can get new revenue streams from the same material. So she keeps doing that, and it's worked out pretty well for her. She's very entrepreneurial as well, so she can, sell her art and redo it slightly, and then new people may look at it differently, even though it's maybe basically the same thing, but it looks different.
Yeah.
But it saves her a lot of effort.
It's repurposing.
Repurposing, absolutely.
I have so much stuff on my computer that I have been going through lately, actually, on my new projects and things like that. So that's good advice. Number 3 says conduct thorough research. So what kinds of research should people do before they file for a patent or a trademark or anything?
Yeah, well, first of all, like copyrights is a very different type of IP. So if you write something and you didn't copy it, if it's exactly the same as someone else's work, you're not guilty of copyright violation if you created it. Maybe you weren't aware of it. Okay. You can have two people who have virtually almost the same story, and they're both can be copyrighted. So it's different. It's not that way for trademarks or patents. Mm-hmm. So like if you're an inventor and you say, I invented this great new device, chances are that somebody else may have worked in the same area or similar. And a lot of the way it works is a lot of times people come up with the same ideas at the same time because the atmosphere is there, everything's ready for it. So you'll see a lot of inventors coming up with inventions in the field kind of around the same time. It's very weird, but that happens all the time. So you really need to do research to see what else has been invented, recently or in the past. So patent searching, field of the art searching is very important to make sure you actually have a right to operate. The worst thing is you invest a lot of money and effort and find out, somebody else patented that 5 years ago and the patent's still in effect. So you can't do what you want to do. I mean, maybe you could license it or buy it from somebody else, but maybe you can't. So knowing, where you are, not flying blind is really good for patents. Trademark research is fortunately a little easier to do it, but also, I always tell clients, unfortunately, it's very hard to get trademarks these days because there's just so many trademarks out there. And, I do look searching and constantly find like the ones my clients want aren't available. Right. Either they're already there with someone else or they're really close. So I have to tell them the bad news, it's not available and I shouldn't go forward. At least it's good to tell them in advance before they've spent the money and have to rebrand because that's expensive and terrible. Right. So yeah, research is really critical, especially for patents and trademarks.
What are some of the mistakes that people make when they do their own research?
I think like a lot of things, it's not as simple as it looks. They may do, I've seen this a lot, like they say, I checked this trademark, it's good to go. And I've learned not to really accept that unless I know the person is like really know what they're doing, because they don't know how to search. So searching is an art for trademark and patents. So I have more resources. I have databases that I pay to use. They're not cheap, but I can get much better results. The search engine at the United States Patent and Trademark Office for trademarks is quite bad, actually. Surprisingly bad. I've seen so many cases where I search it and it should find a result and it doesn't. So I usually use it as a screening tool. And if I'm knocked out of the water, I'll say, okay, great. And if I'm not knocked out of the water using that tool, I'll use the private database searching, and it may find something that should have been found with the free database. So that's for trademarks. Patent searching is quite difficult. We use US-based searchers who are former, examiners at the patent office. So we use private firms that run the searches for us. But what we do is we kind of decide what the parameters of the search are, and then we give it to the searcher. They run the search. They give us the raw results. We review it and kind of give the client feedback as to whether something is patentable or maybe how broad it is. Sometimes it gives us guidance like, well, you can't patent this, but you can patent this other area. And sometimes it comes back with, wow, it's wide open. No one's done work in that area. And that's another question is people think, oh, that's great. There's no patents in the area. Sometimes it means, though, why? Does it mean it's because there's no interest in it, or you're too much ahead of your time, in which case it's hard to sell if you're too much ahead of your time. You want to be just a little bit ahead of your time. Then there's an interest. But if you're too far ahead, no one's interested in what you're doing. So, yeah. Did I answer the question?
I think so. Yeah.
Okay.
Thank you. So number 4, it says file for patents strategically. Determine the optimal time to file for patents to secure the strongest protection for your inventions. So what does it mean to file patents strategically?
Yeah, that would be, I think that's a really, comes down to a cost benefit. So if you're inventing in an area, and you really have to look what the surrounding field is like. So if it's a wide open area, you may be able to get a broad patent. If you're in what's called a crowded field where there's a lot of other patents, you have to be very aware of what other patents are. So if let's say you're working in, ophthalmology, like you're an ophthalmologist and you're trying to invent some new kind of tool you use in surgery. So you have to be aware of what other kind of tools are out there, in which case you might decide like, well, there's already all these other tools and I don't have the ability to get a broad enough patent to protect me because somebody could do a design around and avoid the patent I could get. So maybe it's not really worth getting it if the patent's going to be so narrow. So you have to, in advance of filing, it's like searching is important because you may decide it's not really worth doing because you might only get a narrow patent. Or it might be that like there's a bunch of other patents, but in order to put together all the tools you need, you might need to in-license other things. But that's okay. So basically, maybe you in-license other patents and now you have a very good field, a good basis to work and develop products and services. So that's called being strategic.
Number 5 is keep your inventions confidential. Maintain strict confidentiality to prevent others from stealing or copying your ideas. I bet this happens a lot.
It happens. It doesn't happen a lot, but when it happens, it's really terrible. I've seen it happen many times. Most of the time it doesn't happen, but when it does happen, it's terrible. I had one client, a very lovely lady. She invented something in the personal care market, and she brought it to a manufacturer. I'm sorry, I say cookware. So cookware. So she brought it to a manufacturer. The manufacturer, and she didn't have an agreement. She was pursuing a patent. But unfortunately, her patent never went through because it was very poorly written. I did not write the application. It was just terribly written and it never can go through. So she didn't have an agreement with the manufacturer that said, you cannot make this. You can only manufacture for me, but you can't manufacture for anyone else. She didn't do that.
Right.
So when the patent failed to go through, the manufacturer said, well, you don't have a patent, so we'll just make it and sell it on our own. And so they cut her out, and she was a individual inventor, didn't have a means to fight them off. So basically she lost out because she disclosed to them without a non-disclosure agreement, without including terms that no one could do it unless they worked with her, whether or not they had a patent. And she could have. She didn't know better.
Wow.
Yeah, so most people are good, but there's still some stinkers out there who will steal. So yeah, you have to protect yourself.
Yeah. Yeah. I mean, it's, in a sense, it's called opportunity, but there's also some ethics tied to it as well.
Yeah. Yeah, there's just not, you can't assume that people you're dealing with are ethical, so you have to be careful.
Holy moly. Number 6, file trademarks for your brand. Register your trademark to protect your brand identity and distinguish yourself from the competitors. Talk about why that's important.
Well, yeah, it's important because a lot of times branding is really what sells products. It's not so much the technology. I mean, it has to be good, but if you've got a great brand name, it kind of will make you stand out from your competitors. If somebody has a really it's a boring, uninspiring name and you have a great name that's like a great image, people will at least try your product probably, as opposed to somebody else who has some boring sounding product, generic. Yeah.
There are a lot of businesses that are out there that are riding on the heels of somebody else's brand. So I don't have a specific example, but can you talk about that? What's legal, what's not legal regarding that?
Yeah, that's very common. So, I represent several clients who get copied a lot, and one's in consumer electronics, gaming stuff, like gaming controllers and audio stuff. And so they're constantly being copied, and mostly Chinese companies who come up with names that are really close to their brand name, to their house brands. So we're constantly sending these companies cease and desist letters threatening to take down them if they don't withdraw their trademark applications, or sometimes they don't have trademark applications, they're just doing it. So we have to threaten them, and usually they back down.
Yeah.
But yeah, it's if you have a good name and you start building goodwill, some people will try to copy you by coming up with a name that's close, sometimes even the same, but close is very common. So how close can you be? It depends. The standard in trademark law is confusingly similar. Yeah. So it can be similar, but if it's not confusingly similar so that an average consumer would think like, oh, that must be the same company because the name sounds the same.
Right.
And people don't pay that much attention. So, if you have something that's close, they may think, oh, it must be the same company because the name sounds like it would be from them. So, yeah, you have to be careful if you're the person who wants to name something or brand something that's close to another company's name. You should probably have somebody help you to make sure you're not too close, that you're not being confusingly similar. Yeah. I have these conversations all the time. Somebody said, I'd like to trademark this name. And I go, oh, that's a problem. There's this other company.
Right.
Sometimes I have to do some serious selling of these clients to say, no, that's a bad idea. You're buying a lawsuit. Don't buy a lawsuit.
Especially if you're in the same space, if you're in the same market.
Yeah.
There's yesterday I was at Target and I was buying Ensure. My wife has got some health issues. But there's another product called Premier or something like that. The bottle looks exactly the same. Exactly the same. But it's a different brand and it's like $2 more per bottle. But Ensure was there first. I mean, they're the premier product, right? No pun
Is the
intended.
bottle, yeah, I actually had a similar case like that years ago. I used to represent Natrol vitamin, and Natrol had a certain unique, at the time, they've changed their branding. They've been acquired a couple of times since then, but they used to have like a purple bottle in a certain look. And if someone else came up with a bottle that had a different name, but it was the same font, it was the same color. So if you weren't paying a lot of attention, you would just say, oh, it's neutral because I see the font and I see the color.
Right.
So we were able to get them to, stop, because it was like people just would be confused. You're causing confusion in the marketplace, which is, a violation.
Yeah, this definitely, I think, in my opinion, based on what our conversation here, violates that, because I was about to grab that bottle because I thought it was the Ensure, and it was
Yeah.
a different brand, and it was much more expensive, and I had a coupon. I had a coupon from my previous purchase, and just because it cost.
Yeah, I wonder if there's a lawsuit going on. Probably not, because the retailers don't want to be involved, and if they're selling infringing products, they can get drawn in. So they usually, as soon as they get a letter, a cease and desist, or a by the way letter from one vendor, by the way, we have trademarks and the product you're selling is violating our trademark. It would be a good idea if you didn't sell our product in a nice sort of way. If
Yeah,
you're Walmart or Target, they usually do it in a nice way because they want to sell their products. But
right.
it is something that, vendors will usually say, we don't want to get involved. We're not going to sell your product if there's any hint of a lawsuit.
Yeah, and some brands like that don't they do white label too, or something like that? You can use their product under your own name and stuff like that. So like, I'm wondering if like Ensure has maybe not white label, but give it rights, because when you go to a pharmacy, you see the brand and then you see the store brand, and it looks similar.
Yeah.
I don't know if this product happens to be Target's brand, but it's yeah. Anyway.
Yeah, people try to get close because, it's if people get confused, it kind of benefits the copier, right?
Sure, sure.
I mean, sometimes it's even like a small brand gets copied by a bigger brand, and it's kind of like, it's called reverse confusion.
Right.
Because traditionally it's like a little company tries to copy a big company, but sometimes a little company is having success, so a big company comes in and says, we'll get us beat up on you,
Right.
and we'll do a reverse confusion type of thing.
Right. Just one more example. Funny. It's funny actually. In the movie Coming to America with Eddie Murphy, he works at McDougal's,
Yeah, I
and
remember that
he
movie.
has the
Yeah,
one arch instead of the two arches, and he keeps the owner keeps on saying, "No, they have two arches. We only have one arch."
yeah, I remember that. It was a funny movie.
One more for this part one of the 25 essential tips protecting your IP. Copyright your creative works, register your original creations to establish ownership and prevent unauthorized use. When should someone copyright their creative works?
Actually, copyrights, you could do it anytime. You can do it before it's published. You can do it after. You don't actually have to file a copyright application and get a registration. You automatically have copyright rights, even if you don't put the copyright notice. The copyright notice is the C in a circle, the name of the holder, and then the year. So it'd be like C in a circle, Craig Valine, 2024. And now you would apply it to like a video or a book or flashcards or whatever. But even if you didn't do it, you still have copyright rights. That means you could stop somebody. But applying the notice puts people on notice. So if they copy, then they're more likely that you can prove they copied you because, like, you told them it's copyrighted and you did the exact same thing. If you get a registration, it opens you up to get statutory damages. So statutory damages are by law. They set certain minimums and maximums damages. So if somebody copies you, you could get up to like $100,000 per incident. I don't remember the exact numbers for different types of violations, but it's pretty substantial. And the reason they have these liquidated kind of damages are, that it makes it very easy. You don't have to prove damages. You don't have to prove I actually was hurt by that amount. You just say, well, the law provides I get this much money if you do this act. So it makes it very easy, and it's very effective to stop copying, because people go, oh man, I could be paying $10,000 for each book I'm selling that's a copy. So people stop because they just go, it's too expensive. So getting the registration, and if you do it within 3 months of the first publication, then any copying will be subject to these liquidated damages. If you don't get a registration, and somebody, and a year later you haven't gotten a registration, somebody was copying you a year ago, you can't go back and sue them for liquidated damages. You can only go 3 months back. But if, from 3 months back from when the time you got the registration. So it's in your benefit to get a registration early. So in case there's somebody who copies, you can go and try to get liquidated damages.
Awesome. Well, we did 7 of those essential tips of the 25 tips, and that'll be end for this part 1 series.
Okay. Part 1, yes.
But I do want to just let people know, if people are watching, that you offer a 15-minute call, free 15-minute call with anybody who has questions about their specific invention, course, patent, trademark, trade secret, copyright, all that stuff, questions. And just tell them what will happen if they take advantage of that.
Sure. Well, first, again, it's free. There's no obligation. I'm not selling you anything. If you don't want to go any further, that's fine. But you can get any semi-specific questions answered. If it takes 15 minutes or less, I may spend a little more time. If it's interesting and you're nice, I'll spend a little more time probably. But I can answer questions like, let's say you're an inventor and you want to know how to go about something, like what's the searching process, what my opinion might be, what's the best way to proceed. I can answer those questions. Like I said, I've been an entrepreneur myself, so I know how to use IP. And, coupled with my experience of being an IP attorney for a long time, I kind of know how things work out. So I can give you some good guidance. And unlike invention marketing companies, I don't really want to push people to do the wrong thing. I'm not going to tell you what you're doing is great, it's awesome, you should file a patent or trademark it if it's not true. So get you some honest advice that's actually you can count on. So I can do that pretty quickly and get you on your way. And if you want to work with me further, we can work from there. But just get some information and get you going.
Yeah, a laser focused session together. And again, there's no obligation whatsoever. The link will be right under here after this video. But Dan, thanks for taking the time. We'll do this again, and we'll cover another 7 or so of those tips and expand on them for people who are interested in really protecting their IP. So that is all for today. Thank you everybody for watching, and thank you, Dan, again for taking time to be here.
See you later.